Welcome to CHED Connect, a higher education open educational resource application. CHED Connect contains higher education materials which are useful for teaching, learning, and research purposes. It allows learners and educators to access content anytime, anywhere, free of charge. No registration needed. Just type in the keyword of the topic you wish to search. Click on the categories on the Philippine Standard Classification of Education and browse your way to its rich content. CHED Connect is easy to use. Just key in your area of interest. The site offers different relevant and interesting materials to choose from. Scholarly prepared, accomplished, and uploaded by competent faculty members and contributors from various partner Philippine higher education institutions. Guided by the principles of open educational resources, these materials such as PDF, audio files, ebooks, presentations, videos, and many more are very beneficial. CHED Connect. We educate as one.
Good afternoon, everyone, and thank you for attending the 12th webinar of the Higher Education in the Context of the Bangsamoro Organic Law, also known as the HECBOL Project of the Commission on Higher Education. This is in partnership with the Ministry of Basic, Higher, and Technical Education of the Bangsamoro Autonomous Region in Muslim Mindanao. We are broadcasted live via HECBOL's Facebook page and YouTube channel. I am Jean Hesuro, and I'll be your moderator for this afternoon. Our webinar is entitled Setting Boundaries, Safe Spaces Act in the Context of Flexible Classes in Higher Education. This webinar focuses on the discussion of the Safe Spaces Act or Republic Act 11313 and its application to the flexible classes in higher education. To formally begin our webinar, please help me welcome the Director of the HECBOL Project, Director Nelia A. Alibin, for the opening remarks.
Thank you, Jean. Assalamu alaikum. Good afternoon, everyone, most especially to the presidents, heads, faculty members, and students in the Bangsamoro Autonomous Region in Muslim Mindanao, my colleagues in the Commission on Higher Education, and our partners from the Ministry of Basic, Higher, and Technical Education, BARMM, school officials, and guests. It is my honor to once again welcome all of you to HECBOL Online. Welcome to our 12th webinar entitled Setting Boundaries in the Context of Flexible Classes in Higher Education. This is part of CHED-HECBOL Project's capability building activities for the higher education institutions in the country, most especially to the Bangsamoro Autonomous Region in Muslim Mindanao. The webinar today focuses on RA 11313 or Safe Spaces Act. This act protects everyone from sexual harassment, both in physical and online spaces, and not just by persons in authority. We in CHED believe that through this Safe Spaces Act, everyone can now freely walk the streets at any time of the day, comfortably go to work or school, and easily go online without fear of being sexually harassed. The Safe Spaces Act is a relevant and timely law addressing all forms of sexual harassment on all gender, public spaces, and online. With the passage of this law, no one will experience sexual harassment anywhere again. The main purpose of this webinar is to let everyone know that sexual harassment promotes disrespect and it is a crime punishable by law. For today, our speaker, Attorney Pilariza Racho-Baldovino, will be sharing her knowledge on the Safe Spaces Act or RA 11313. She is a professor of the College of Law and the Registrar of the Senior High School of Ateneo de Davao University. Thank you, Attorney Reese, for accepting our invitation. As an end note to all our followers, I want to express my gratitude on behalf of the Commission on Higher Education and, of course, the HECBOL Project. We hope that you continue to watch our webinars, follow our HECBOL FB page, and subscribe to our HECBOL YouTube channel for some updates about higher education, about CHED activities, and of course, other reminders. I express my sincere thanks to all the many individuals from CHED, the BARMM Ministry's Basic, Higher, and Technical Education, and to all our subscribers. Let us continue to contribute to the success of higher education. Thank you.
Thank you, Director Anibin. To those who just tuned in, welcome to Setting Boundaries, Safe Spaces Act in the Context of Flexible Classes in Higher Education, the 12th webinar of the HECBOL Project of the Commission on Higher Education. Without further ado, let me introduce our resource speaker for this afternoon. She finished her Bachelor of Arts in English, Master of Arts in Teaching of English, Bachelor of Laws, Juris Doctor, and Ph.D. in Education Administration from the Ateneo de Davao University. She also holds a certificate in communicative teaching of English from Lancaster University in England. She was a visiting professor at St. Aloysius Gonzaga English Language Institute in Myanmar, Summer Institute on Contemporary American Literature of the University of Louisville in Kentucky, USA, and the Philippine English Language Training of Lancaster University in England. She was the chairperson of the Humanities Division of the Ateneo de Davao University from 2005 to 2008, and the chairperson of Teacher Education Program of the School of Education of the same university from 2015 to 2016. Currently, she is the registrar of the Ateneo de Davao Senior High School Unit, the vice chairperson of the Board of Directors, and the chairperson of Education Committee of the Ateneo de Davao Employees Credit Cooperative, the editor of Mindanao Law Journal, and a professor of the Ateneo de Davao College of Law. Ladies and gentlemen, an educator, researcher, book editor, and experienced trainer, Attorney Pilariza Racho-Baldovino. Good afternoon,
Thank you,
Attorney.
Jean. Good afternoon, Jean. And I'm
Welcome
glad I'm
to
here.
welcome to HECBOL Online, and you may now proceed with your topic.
All right, thank you. Okay, can you see my presentation?
Attorney, let's go through the share screen again.
Okay.
Yes.
Have I shared it?
Yes, it's here. All right.
It's okay. So we'll take a look at the law that we are to. Do you have that, Jean? Is it on the screen?
Yes, Attorney, it is. It is now.
Okay. All right. So today, let's take a look at a new law. This was sometime in April 2019 when this was implemented and enforced. Okay. This is called RA number 11313, otherwise known as, in a short term way of addressing the title because the title is quite long, also known as Safe Spaces Act. So what is this all about? Now, we'll take a look at the concept of harassment, this time both in the physical and also online. Right now, with a kind of learning platform that we have, most of our classes in college are actually on the online platform, and it's only seldom that we go on a face-to-face or physical transaction classroom. I call that now, there's a new term for that. It's learning the traditional way and learning the virtual way. So, could we also be harassed when it comes to our online platform? And the answer is yes. Now, it refers, when we talk about gender-based online sexual harassment, we refer to an online conduct targeted at a particular person that causes or likely to cause another mental, emotional, psychological distress and fear of personal safety, sexual harassment, including unwanted sexual remarks and comments. So basically from that section of the law, I highlighted 4 terms: online conduct, particular person that causes distress and fear of any unwanted sexual remarks and comments or threats. So later on, we'll take a look at how this is done. But basically, that's a definition of what we mean by gender-based online sexual harassment. So then the main question that comes to mind is, how does it happen? We'll find out later. Now, when we talk about public spaces, we talk about anything and everything that is outside our home. So you go like streets and alleys, public parks, schools, buildings, malls, bars, restaurants, or even transportation terminals, public markets, spaces used as evacuation centers, government offices, PUJ or PUVs, as well as private vehicles covered by the app-based transport network called Grab or something else, and other recreational spaces such as, but not limited to, cinema halls, theaters, and spas. So if you take a look at the law, it is actually quite encompassing because of the term, but not limited to. In other words, there are areas which may be privately owned, but considered as a business center that will be covered under what we call a public space. Now, what is the reason for expanding the coverage of RA 11313 from our previous law on sexual harassment, RA 7879? The coverage, the scope, therefore, of RA 11313 is much broader. And because of its broadness, it covers a lot of spaces where any human person who is either on the street waiting for a jeepney or riding a jeepney or a bus or in the terminal or in the airport, they are to be protected. That's your physical space. Question, what about on the online space? Yes, later on will come up that the concept of a public space can even go beyond the physical parameters of that which had been defined by this particular section of the law. So then we take a look at the crimes of gender-based streets and public spaces sexual harassment. So they are committed through any unwanted and uninvited sexual actions or remarks against any person, regardless of the motive for committing such actions or remarks. Again, I highlighted certain terms in this particular section. Any, that means it could be anything perceived by me, the recipient of that sexual action or remark, to be unwanted and uninvited. And it is any, but it has to be related to, our qualifier is sexual. And therefore, these unwanted and uninvited actions or remarks have to have the connotation of sexual notions. Okay. Now take a look at the next term. It says any person. Does it mean only male and female? No, it does not actually differentiate the person that gets to be the victim of these crimes of gender-based streets and public spaces sexual harassment. It is targeted at a particular individual, any person, any human person, regardless of the motivation, regardless of the reason, regardless of the purpose of the perpetrator or the offender when he or she releases such actions or remarks. Again, the actions or remarks have to be sexual in nature. So how is it then committed? This is in the physical space, but can it also be done in the online space? And the answer is yes. So how is it committed? Catcalling. You know, when you wolf whistling, when you for men or women, or for those who also belong to the LGBT, when you use what is it, signs or symbols, or when you eject certain words or signs coming from your mouth that is unwanted, and it is of course unwanted and pervasive on the victim, or when you release comments or gestures which are misogynistic, which means basically against women, and transphobic, that where you get to release remarks, release comments on those who are transgenders, or homophobic, those who are gay, both male and female, and even sexist slurs, sexist comments, sexist insults, which are persistent and uninvited comments or gestures on a person's appearance. And there is also another way of committing it, a relentless request for personal details. Look at the terms that the law has used in this particular law, in this section. Relentless, meaning unending. It is stated, it is repeatedly requested. Personal details that to us will be covered by our own privacy, by the fact that there are certain information that we do not release unless there is a specific reason for that release. But this offender continues to incessantly, relentlessly, continues to repeatedly request for personal details. So one example for this is, well, it could happen anytime and anywhere, online or physical, when the perpetrator would ask for your phone number and you don't want to release your phone number. And he continues to request for that phone number. And then, well, for one who is a victim of that, you get to feel uncomfortable, but it is a discomfort that is rooted towards the invasion of my personal space. And therefore, if you don't release it, you feel threatened, and the atmosphere gets to become even more demanding and threatening. Or it could be committed via statements of sexual comments and suggestions. There is one thing about our being Filipino where we think of green jokes per se as simply green jokes. And so we release it either physically or in a physical space or in an online space. But the green jokes are not, in a way, jokes for the recipient, because you have to take a look at where she or he is coming from. And if he or she is not comfortable listening, looking, reading your green jokes, then that is already a, a sexual harassment that is being directed on one particular person. So green jokes for us are already taboo. Green jokes for us are no longer to be found in the online platform, or even in our physical world, in the way we get to communicate, we get to relate to people, whether it be in the physical space or online space. So public masturbation or flashing of private parts, this can also be done in the physical space as well as that of the online space. I don't know why that happens, but I've already received comments on this one from young people. And even young people find this quite disturbing, that a friend who had been a friend for quite some time suddenly on an online platform changes the way he relates to this particular young girl who came to me. And he said, is it okay, Tony, if he flashes his private parts online when we converse? And then I said, do you think it's okay? And then she said, no. And then I said, how do you feel? And she said, I felt very uncomfortable. Is that sexual harassment? It is. But then you say, but he is my friend. But even then, you see, it can be committed by any person targeting another person. Okay, and whatever is happening there in the online or in the physical world, it has sexual meaning for that particular act that was committed against the victim or against the complainant. Groping, this is physical. You cannot do this online. Groping is when you touch private parts of the other person. When does this happen? In the elevator. Now remember, in a physical space like an elevator, where there's say around 15 or 20 people in, and I always tell my students, when you enter a crowded elevator, you make sure that you protect your private parts. For the male, that which is considered private, and for the females, the upper portion, which is considered private. Why? Because groping can happen there, and this can happen by a friend, or it could be done by a stranger, or it could be done by a schoolmate, or it could be done by a teacher or a professor or an administrator. Because it is the concept of anonymity in an elevator, in a crowded train, in a crowded car, in a crowded PJ, that one gets to believe that this anonymity will protect him from being known by the person who gets to be the recipient of his sexual advances, of his sexual groping, or any advances, whether verbal or physical. That is, and this is our common denominator from those which I have enumerated as a list, previous slide, and also this. It is unwanted and has threatened one's sense of personal space and physical safety. Question: what do you mean by personal space? Personal space among Filipinos is like, it actually is different from one person to the other. But what is common that we say, I get to be safe in my personal space, is a distance between me and the other person to, let's say, 2 to 4 feet. After that, if one goes inside my private space, I feel threatened, because that to me is my personal space where I get to feel I am protected, I am secured. And that if you violate the 2 to 4 feet that and you come near me, then I feel I have to back off. And you'll notice this if you get to observe young people, our students, and even the faculty. When one enters into the personal space of the student or of your colleague, then you will notice that the immediate response of that student or of your colleague is to back a step away, to retreat. If you see that, then at once you must also back off, because you have violated the personal space of that human person whom you are communicating with. So, must sense that I feel threatened when you enter my personal space, or when you enter that space which we consider to be safe for me, whether I be male, female, or I belong to the LGBT, and then you say, I am no longer safe in this particular space. I'm no longer safe in this environment. So where is it committed? Let's take a look at physical spaces. This would be committed, these gender-based streets and public spaces, sexual harassment are performed in buildings, any building, a school that is still a public space. Why is a school a public space? Because it is open not only to our students, but also to those who would like to communicate with us or to perform certain transactions, okay? And so therefore, there is a certain decorum, certain actuation or behavior that is expected from all of us when we are in a building, whether it be government building or a private building, in schools, whether that be private schools or public schools, in universities or state-run universities and colleges, and then also our private universities and colleges, in churches, restaurants, malls. These are public spaces, even a public washroom, or even in the washroom, or we call that the comfort room, the restroom of malls or of churches, the public restroom or the restrooms of restaurants and of schools. And here, these are considered public spaces. And then you have internet shops, bars, public markets, transportation terminals, or public utility vehicles. Inside a public utility vehicles, like a van that you use to commute from your place to Davao City or to any other home city. So these are considered to be a public space. And once this is, once my personal space, and once you perform the gender-based sexual harassment in these areas, then I feel I have been violated, you caused me a great discomfort, then I can complain. Because the main thing here, what is the core here? That I must feel safe. Even if I walk alone, or even if I ride alone, even if I go to school alone, even if I'm alone in the classroom, even if I go to church alone, even if I eat alone. You see, all these things do not say that you can do anything to me that is sexually harassing me, that you're sexually harassing me, and that you give me discomfort, where that discomfort I should not in any way be in. Okay, next. Now, let's take a look at how is it committed online. Now, this is very important. Our Safe Spaces Law, RA 11313, is very important. Why? Because right now, the way most of us conduct our classes is via online. So then you ask, then I will not be committing any sexual harassment at all on my students, or when I go on a meeting with my colleagues, or when the administrators call for a meeting, or when there is a committee meeting. So when I do my online classes, and actually I'm not very sure if you get to be monitored or if the monitoring is scheduled. And so you say, okay, I own the online class. Now I have my students and me, and therefore there could be no sexual harassment that happens here. But then I say there is. Otherwise, this law would not have come into fruition if there had been no complaints, if there had been no situations where through online, these acts have already been committed. And so when you go for information communication technology, this means to say this is now our cyber world, that acts that use our ICT in terrorizing and intimidating victims through what? Through threats. You type, let's say, a message. You did not like one of your classmates in an online class. And then remember, in an online platform, you have the teacher goes into an online class, like a Google Meet or via Zoom. And then there is a certain portion there where students can interact between and among each other, and also with the teachers. Or there's a break room, or there would be some announcements, and you go take a look at the forum that is set up, and then you go like communicate with one or with each other. But in your messages, in the chat for that particular class, you threatened another, whether it be a teacher or whether that be your classmate or the schoolmate, that they say, after this class, wait for me at the garage, we're going to have a little physical boxing. Okay, even if that's a joke or not. The thing is, you threaten the other person who is the recipient of that message with physical pain or physical harm. What about psychological? This is how you go psycho on the other person. You write, you threaten him again via online in class, or perhaps via your private messages through PM, or even through the wall of your Facebook. You go psycho on him, you threaten him emotionally, but the threat is very, very specific. Okay? Yes, that reminds me. There was one, I don't usually receive clients at all, but for this particular instance, 2 days ago, I received one because the purpose for visiting, of course, with the usual face mask, and we also had our protector, was there was an immediate need for consultation with me. Why? Because using that online platform of a mature person, 21-year-old student of a university, against a 13-year-old minor, a boy still in junior high school. And the threat was very specific when it was written on the wall of the person who threatened him, this young person. So, but then you say, it was my wall, and therefore I own my wall. Take note, you own your wall, no problem with that one. But on your wall, but if on your wall, you place a threat against another person who gets to read it. If it's a public wall where everyone can see it, obviously the person whom you intended the threat to go to or whom you have targeted can also read that wall. And he felt, that minor felt very, very frightened. Okay? So when the consultation came, and then asked, what is the nature of the threat? And then when I read, because you can screenshot that which had been posted and you can print it, okay, for the consumption of the person who felt threatened prior to the filing of the case, it was actually sexual, very explicit, graphic is the threat with regard to a private part of this minor and what he's going to do with his private part. Okay, so even in ICT, in our online medium, we can terrorize, we can intimidate a targeted individual or a targeted victim. In this case, a person is 21 years old, a university student against a minor. Well, that's a very heavy action. Next is unwanted sexual misogynistic, meaning against females, transphobic against the transgenders, homophobic against the gay community or a gay person, and sexist, meaning for the regular male or female remarks and comments online, whether you do it publicly or through direct and private messages. Question: isn't the group chat that we have created private and will only be for the consumption, those which are placed there, for the consumption of the members of the group chat? The answer is no, it is not. Because any member of that group chat can have a screenshot, can do a screenshot on what had been posted there, and can disseminate it. There is no privacy in a group chat. In a group that you've created specifically for this number of people to belong to that chat group. So there's none, just one, to screenshot it and to deliver it to the other who is the victim of your conversation that is sexist in nature, or you can also post it online, or you can spread it privately via PM. Therefore, does it mean that there is any privacy in Facebook or in Twitter or in Instagram? The answer is no, there's not. Anyone can grab it, can do a screenshot on it, and then can disseminate that information. Did it happen in a school? Yes. Does it happen among colleagues? Yes. If our text messages can be grabbed via screenshot and disseminated outside to those who are not members of our text group, then do not expect privacy to happen and to actually be existing in an online platform. Invasion of victims' privacy through cyber stalking. What is cyber stalking? It is, I think we already know this in Facebook or in Twitter or even in Instagram. I think there's a new one. You can even have it in the other online platforms. There are a lot of online thingy that has come out. Cyber stalking means to stalk. Because when you go for the search, if you press the search button and then you write there the name of your intended victim, The whole information about the intended victim, including the photos, are actually out there, and you can grab. So you stalk, you're not a friend, but you don't even know, you want to be added as a friend, but you know what he or she is doing. That is cyber stalking. Because if you're actually a friend, then you don't simply like and do the heart comment there if it's Facebook, but you make a comment to know that the other person, the one whom you wish to communicate, is aware that you actually saw the photograph or read the message. But if you're cyber stalking, you're not a friend. You simply want to know everything there is to know of your intended victim. Why did I say that? Because when you stalk, you don't do it in a friendly way. No one, no friend would stalk you. Now, if you are not a friend, if you presume or you assume that you'd like to know more because you want to get to know him or her better, and then you didn't even tell this person, your victim, this person who is the owner of that online info, you did not introduce yourself to him or her, then that is actually part of what we call stalking. And this, again, the repetition, messages which is incessant, no ending, repetitious, balik, 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 balik. And even the emails, balik, 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 balik. You keep on sending the same content of the email every day and even every hour. This is going to threaten the recipient of the email or going to threaten the owner of the Facebook account or of the Twitter account or of the Instagram account. And then you uploaded and shared messages or photos without the consent of your target victim. Did this happen? Yes, it did. When was that? A year ago, when we had a physical traditional classroom, we had a problem. It's not really a problem, it's a concern because one child, one minor, placed in her Facebook page pictures of her in, well, very, very appropriately dressed actually, but she's actually quite pretty also. And she placed there when she went on vacations, and this was what was posted. And then when she touched the Bengali tiger in, I think, in Singapore, and then that was what was posted. So what this stalker did, this perpetrator did, was to grab. These are peers, these are minors. Grab the image from the photos that is part of her information, and without the consent of the owner of that photo, started to share it. And with the sharing, because you can edit photos, there were already comments in that shared photograph. And of course, the victim, the one who owned it, or somebody told the victim. And so when she opened her Facebook and then she saw this, because they are actually part of a bigger common group or common friends. And then when she saw this, she filed a complaint. Because the owner of the photograph, even if it is in a public space like online, you own it. If you want to get it, you must ask permission first. Hello, I am going to have this as for my memory of you. Can I grab this photo that you uploaded? And then if the victim says yes, then you can upload it. It is with consent. Therefore, there is no sexual innuendo there. And if you edit the photograph and you made it into something sexy when in fact it was not, and even with the consent of the victim, take note, the consent of the victim was in the grabbing of the photo that was uploaded. The victim did not consent to you editing the photo and made it and place some sexual innuendos there. And so the victim now can complain against you because consent is only in the grabbing of the photograph. No consent was given to the editing of the photograph, making the victim be one as if she is what's a term that the young people are using? Slutty. Okay. Another one, take a look at this one, because online gender-based sexual harassment can also happen in any form of media. So you can go online, you can go print, you can even go radio. Why? Because look at that, there's a voice recording with sexual content, and you can put it on radio. It can be broadcast, okay? Or if you want to, you can go use the print. So any form of media, whether it be posters on print or whether it be online or radio or television. Or even this one, even the passing. Remember, mom, I didn't actually place it. I wasn't the person who did that. What did you do? I only shared. Sharing the photograph or sharing the voice, sharing the video with sexual content to another is already a violation of RA 11313, because any form of media that contains photos, voice, or video with sexual content. So the mere act of sharing will already be tantamount to you being a perpetrator of gender-based sexual harassment. Okay? Because there is a target person. You have targeted this person to be the recipient of your harassment. And you may not be the first person who actually placed it there, but you share that to me and that to the law is already synonymous with you actually doing the harassment. Any unauthorized recording and sharing of any of the victim's photos, videos, or any information online. I underlined unauthorized. Okay. How is it committed online? This one is actually quite common today, and we have a lot of complaints about this. These three: impersonating identities of victims online. You grab photos, and then you create another account, and you can go into an alias or a pseudonym, and then you put there the information coming from a legit owner and including the photograph. And then you place there so many photos which were actually no longer that of the young person that you have stolen, whose identity you have stolen. And then also you place messages there that were sexual in nature. And then those who knew this, and you even request her friends, because you already have that list of friends in the legit owner of that identity. And you ask them to add you. And once you're added, then what you do is you destroy, you impersonate, and you now post lies about this person to harm their reputation, to besmirch their reputation. So messages, or you have their additional photos that those who read it may believe to be that coming from the legit owner. And then sometimes what you do is you also file false abuse reports to online platforms. If the victim complains, then the perpetrator files a request from let's say from Facebook to delete or to deactivate the legit owner, because, and then you come up with all of those lies that will eventually make Facebook or the online platform deactivate the legit owner, the original owner of that one. Question: what if my messages were not sexual in nature, but I impersonated the identity of the victim, that I posted lines about the victim because I don't like him, I don't like her, and I also filed false abusive reports to the administration. So what happens? Can I fall under the gender-based sexual harassment? Can it fall under RA 11313? And the answer is no, because those messages were not sexual in nature. You will fall under the violation of another law, cybercrime, and you will still have to answer to the government. You have to answer to the victim on what you did. Okay, so this one, RA 11313, is actually very specific. It only falls on sexual harassment, given those which I've enumerated in the previous frame. Okay. Now, in the workplace, okay, this can be both physical and online. So an act, take note, one singular act involving one singular unwelcome sexual advances, request, or demand for sexual favors is already a violation of the law. A series of acts, what does a series mean? Two or more. One singular act or two or more involving any, the coverage is so broad, any unwelcome sexual advances, requests, or demand for sexual favors, any act of sexual nature, one or more, whether done verbally, physically, or through the use of technology, or through any other forms of information communication systems. Let's paraphrase that. An act, just one, or two or more acts involving any, very broad, any unwelcome sexual advances, requests, or demands for sexual favors, whether it be physical, verbally, or through online technology, emails, private messages, calls, or you can have a video call, okay? And this is now the commonality among all those that have been given that has or could have a detrimental effect on the conditions of an individual's employment or education, job performances, or opportunities. Take note, because that first paragraph is actually very subjective. Okay? Why? Because it's any unwelcome sexual advances, any unwelcome request, any unwelcome demand for sexual favors. Sometimes you are not very, the perpetrator may not be very explicit in stating it, but implied, if you infer the invitation, the advance, the request, or the demand, the recipient, the victim infers that this one has a sexual connotation, then that could be interpreted as sexual harassment. And if you say it is not, we'll take a look at whether there's a reason or no reason at all. Take a look. Because in RA 11313, there is no reason or motivation needed by the perpetrator to perform these acts against the victim. So if the victim perceives, if the victim subjectively infer from your actions, from your words, from your touch, or from the use of our ICT, that you are harassing me, then that you have created an atmosphere for me which is going to affect the conditions of my employment, my education, my job performance, or my opportunities. That is already gender-based sexual harassment. Did that also happen in RA 7877? Yes, but the main difference there is that if in RA 11313, there is no need for any motivation or reason behind the actuation, in RA 7877, our anti-sexual harassment law of 1995, there is a reason. Okay? So, in the workplace, conduct, behavior of sexual nature, and other conduct based on sex affecting the dignity of a person, which is again unwelcome from the perspective of the recipient, of the victim, unreasonable and offensive to the recipient, to the victim. You see, the conduct, the behavior, the actuation, an act is very specific. Any series of acts, very specific will be that action. But here it is the conduct of, it's the behavior of sexual nature and other behavior based on sex, affecting this time the dignity of a person, which for that recipient is definitely unwelcome, unreasonable, and offensive, whether it be done in the physical space or in the online space. That is already gender-based sexual harassment. Another gender-based sexual harassment committing would be any conduct. You see, it's A. It's not in any way particularized. It's non-definitive. A conduct that is unwelcome and pervasive. What is pervasive? Pervasive is that which gets into the personal system of the recipient, of the victim. That which makes her pervasive is that which gets inside the heart and the soul, or we call that the I-ness of the human person, the core of the human person, that creates an intimidating, hostile, or humiliating environment for the human person, then that one is already gender-based sexual harassment. I find your behavior unwelcome. Why? Because there has a sexual connotation to it. I feel that I am being targeted from your perspective because I am a woman, or because I am a man, or because I am an LGBT. And that this unwelcome, this pervasive, I cannot sleep at night anymore. I keep on thinking about the way you've acted to me, the way you have done this in my online platform, in my page, or the way you get to send me private messages, or even the way you wrote this in our group chat. I don't feel comfortable. But it even goes beyond discomfort because it is pervasive. It is all encompassing and now goes into the core of my humanness, of my being a female, of my maleness, of my being an LGBT. And therefore, the effect of this is creating an intimidating. I feel frightened. You frighten me. You intimidate me. You create a hostile atmosphere. You create a humiliating environment for me. Because anything that you do, any conduct, any actuation that you do, which is sexual in nature, has an effect on your target recipient, on your victim. And that effect is actually soul crushing. It's not only bone crushing, that's very physical. It's soul crushing. The victim actually has to go, there's what you call a stress, a post-stress, that the victim has to go into counseling. In school, we have that, our wellness and our counseling center. And they provide this so that the victim will, in a way, get to manage the humiliating environment that she had to go through, the intimidating, hostile environment she had to go through because the perpetrator did this to her. It has become so persuasive that the I-ness of my being human has been damaged, cracked, destroyed because of what you did. Sexual in nature, that actually goes into the core of the who we are. And sometimes it is easy just simply to be hit or to be punched in the face. Very simple. If slight physical damages you can file, or if it is a grave or serious physical damage. But that where it is the I-ness, the coreness of me, the core, the gist of the who I am, the essence, that one will take a long, long time for the victim to be reconciled and even to manage an environment where she had to go through that kind of harassment. Provided that this is where you have the differentiation, the male differentiation. It's actually the core differentiation between RA 7877, our Anti-Sexual Harassment Act, and that of RA 11313, the Gender-Based Sexual Harassment Act. And this is our main differentiation. The crime of gender-based sexual harassment may also be committed between peers, colleagues, classmates, same age, okay? Student to student, barkada to barkada, okay? Because that is not found in RA 7877. Number two, the crime of gender-based sexual harassment may also be committed to a superior officer by whom? By a subordinate. Remember in 7878, 7879, you have there in the Sexual Harassment Act of 1995, what you have there is a power. The motivation, the reason for the harassment is based on power. Okay, so the power, the one who is superior, or the one who has moral ascendancy, or the one who has authority over this person, and this one is powerless. The victim is powerless. But here, you see that it's a top-down thingy. But in RA 11313, it is no longer only with top-down, but now we go bottoms up. It could be lateral, between peers. It could also be committed by a subordinate to a superior officer, to a person in authority, to a person with influence, to a person of moral ascendancy, or it be committed by a student to a teacher and a trainer by training. We'll take a look at student by to a teacher by a student. When RA 9877 came out, the Sexual Harassment Act of 1995, the first thing, we implemented it in school. We formed the CODA, or the CODI rather, and then we placed that in our student handbook. But then the main question that our professors asked me was, attorney, what if it is the student who harassed me sexually? And I said, what do you mean? And then he said, because he's a male professor, quite good looking, young, not yet in his 30s at the time he raised the question. He was teaching statistics. And he said, when I give the grades, and when I open my laptop and I show them the grades, and I call a group of students to come over so that one by one I can give them the grades. the the female students would normally go behind me. And then I noticed that one or two of these females, these are college students, okay, would press herself on my back. And I really mean press, so that I can feel her breast really behind me, and then even touching my back. And isn't she harassing me? And I said, well, yeah, she was harassing you. And then what did you do? So he said, so I started to move forward to the child. The student will no longer, I can no longer feel the breast of the child imprinting themselves on on my back. But when I did that, so too the student, the female student, also pressed herself even more behind me. So then my question, attorney, is, can I not file a case, a complaint against my female student because I felt sexually harassed? And my answer then was no, because it is, the law does not cover the harassment committed, the sexual harassment committed by a student to a teacher. But now, with RA 11313, there is now this law that says gender-based sexual harassment can be committed, is committed, will be committed by a teacher to, by a student to a teacher, by a trainee to a trainer, by a subordinate, by a faculty to the administrative head, by a faculty towards another faculty, by a student towards another student. And therefore, it is no longer limited to power play between top down, but it is now going to be a harassment that is going to happen in reality, in the physical space or in the online space, among peers, lateral or bottom up, or up and bottom. You see, now there is a whole picture of expansion of the law. I think this was in a street term, this law was called Bastos law. Okay, next. How should the school respond? It is very important that we in school, whether we be from the basic education or we be from the higher education, that we respond, okay? In the same manner that we responded when 78, 79 came about, okay? So all schools, whether public or private, shall designate an officer in charge to receive complaints regarding violations of this act and shall ensure that the victims are provided with a gender-sensitive environment that is both respectful to the victim's needs and conducive to truth telling. Take note. In Let's take a look at the higher education. They have an office called the Office of Student Affairs. Okay, there's a director, but the officer in charge need not always be the director of the Office of Student Affairs. I remember when I was the assistant director of the Student Affairs back in the Ateneo, the director was Ricky, but then there was a need to have a female assistant director and female and a lawyer to help him go into responding to certain cases. But then he said, your desk is going to be equivalent to a women's desk in a police station. And I said, what do you mean? You're going to accept complaints, accept narratives. I call them narratives first before they are transformed into complaints. You listen to the narratives of our students concerning sexual harassment. So that is from the perspective of RA 7879. True enough, I did that. So I became the officer in charge to receive the narratives and eventually to receive the complaints regarding violations of RA 7879. Correct. Sorry, 7877. And I listened. And there was, I listened, and then I took notes. I identified the legal issue. I extracted the legal facts that would support the legal issue. And then I said, okay, this is viable. There is probable cause, and therefore you can now file the complaint. Okay, because the officer in charge has to be very, very knowledgeable about which, from among the statements in a narrative, will actually comprise those facts which would point to a gender-based sexual harassment. In the case before, it was that would point to the violation of 7877. Okay? Now, every school must adopt and publish grievance procedures to facilitate the filing of complaints by students and faculty members. Okay, now they have broadened the scope. Okay, now with regard to faculty members in the Ateneo, in the implementation of 7877, it was not within my level that I get to listen to the narrative. As assistant director for OSA before, my role was simply to be the officer in charge, to be the recipient of the narratives of students who complain. But when it comes to the faculty or administrators who get to file certain complaints along this line, then that was given to the human resource. Okay, so that would be within the jurisdiction of the human resource office, not with me, because ours would simply be our job in school within that level would only be narratives of our students. Teachers against another teacher, you go to HR. Teacher against an administrator, you go to HR. Administrator against a higher administrator, you go to the HR. Okay? So the second one, the school must adopt and publish grievance procedures. This one actually falls within our coding. The school must create a coding, a committee on investigation, committee on decorum and investigation. Why? Question: is it can the OSA handle, because there's already the assistant director who handles who listens to the complaints of the narratives of the children and a complaint is filed. Will the OSA, the assistant director, be the one in charge also of investigating and then of forming finding a resolution to the complaint that has been filed? And my answer is no. I don't handle this. Why? Because there has to be a separate committee, the Committee on Decorum and Investigation, that will respond to the complaint filed in my office. I file it, I move it, I turn it in to them, and they conduct their investigation and their resolution. Because, why? Why is it like this? Because I am not a one-man army. No director is a one-man army. The narrative of a sexual harassment, gender-based sexual harassment, or simply sexual harassment that happens in school, that happens in an education or an institution, cannot be handled by one person alone. The narratives may also mean that, the human person can also get affected. Even lawyers can get affected, although we try as much as possible not to be affected. But to listen impartially to a narrative, when a female comes to me and then I act like a female, if I'm alone there and I'm the only one listening, my tendency, my desire is to protect the young person, the young female, back on 78, 77, that this I'm going to protect. But then that makes me partial and biased. And therefore, let a CODI be created in school so that I only get to listen, I get to file the complaint, and then I get to turn it in to you, and then the committee will conduct the investigation, because the committee is formed of, let's say, 4 or 5 that you've chosen to handle that committee for this particular purpose, for that specific purpose. So now there is an unbiased, there is an impartial way of looking at the truth, and therefore there's going to be a better resolution than that one coming from one single entity. Now, this is also very important, because if the individual, again, the individual refers to the human person, male, female, or belonging to the LGBT, transgender, transsexual, and the others, but still considered human persons, which I believe are human persons. And as educators, we believe no matter their sexual orientation, they are human persons. So even if an individual does not want to file, it happens once a narrative has been given. And then I say, okay, now let's formalize it, because your narrative, this is the violation, and therefore, if I were to extract the legal facts, significant, essential for this particular violation, and this is how it's going to be. All right, so we will now write it down. Okay, do you agree with this? And then the student says, the female student says, no, attorney, I am not going to file anymore. In 78, 77, okay, so we just dismiss it. Or there's another way of doing it. We can, but we're not actually imposed to do it. It's not mandatory. You don't want to file, okay. Your parents agreed that you will not file. Yes, I even call the parents to ask them, and they get to know the truth, And then the parents say, no, representing this minor child, we are not going to file. One reason is the other person is richer, far influential than they. They do not want their child to undergo this humiliating experience all over again. Okay, so we cannot do anything about it because the complainant does not wish to complain, to pursue for complaint. But in RA 11313, the law now very specifically and expressly wrote this down, that if the complainant, if the individual whose narrative of sexual harassment, gender-based sexual harassment has been filed or has been expressed to you or to the committee, to the CHED, and then suddenly backs out or retracts her statement, retracts her narrative, the school, okay, may take action. Why? Because the school authorities have knowledge or reasonably know about a possible or impending act of gender-based sexual harassment or sexual violence. The school will, auto proprio, conduct the investigation, even if the complainant does not wish to become part of it anymore. So, because they've heard, because the committee have heard, they may continue to do the investigation and find a resolution or a decision, even without the presence of the complainant. Okay? Even in court, an affidavit of resistance or an affidavit of retraction is not really given so much weight, because you can retract your statement because of fear, because the other person has persuaded you not to. The court can continue to investigate and then to come up with its decision. So likewise, it is copied also in our CHED, in the school. So the school should promptly investigate to determine the veracity of such information or knowledge and circumstances under which the act of gender-based sexual harassment or violence were committed, and take appropriate steps to resolve the situation. That's the first condition. The complainant gave a narrative, backs out, and then the school, because it already has knowledge or reasonably know. What do you mean by reasonably know? Reasonably via testimonies in the conduct of the investigation. Witnesses came out. They are reasonably knowledgeable about what happened, about a possible or existing act of harassment or violence. Then they may continue to investigate, continue to find a resolution to this. Now, there's another condition. If a school knows, and now there is no longer any complainant, look at that. The previous slide said there was a complainant and then retracts. The school continues to investigate and eventually comes up with the resolution. Now, the second condition is if the school knows, without a complainant, the school knows or reasonably should know. What do we mean by that? If it is online, it is quite usual for schools to have to have some, not trolls really, but part of the office, some people will be contacted to just, monitor, I think that's the term, to monitor the Twitter feeds that talks about your school, okay, or to monitor there's a Facebook chat group called, what do they call it, confessions, okay, so you could monitor that one, or monitor the feeds of your students. Monitor, not to stalk, but to monitor. And therefore, it is there that some reports will go to you. And so the school, the authorities know, and reasonably should know. Now, you're aware that certain conditions, let me see, what's happening to the online class of, and so you monitor the online class of this particular professor. And then you notice certain innuendos released in the class. Or you you could also monitor your students. That will be part of the evaluation, and you also notice that they get to say things which are not usually said in an online platform for this particular subject. The subject is statistics and probabilities or engineering, and then the conversation, the chat group, is not actually about the lesson, but about something else, targeting one person or the professor. And so you have reasonably should know that there is something quite peculiar here about acts of gender-based sexual harassment or sexual violence that created a hostile environment. Then you must immediately, the school authorities must take immediate action to eliminate the acts, to prevent their recurrence, and to address the effect. In other words, because of the online classrooms that we have, because of our virtual learning, we cannot be complacent. Our administrators cannot be complacent. Our teachers cannot be complacent with the occurrence of this gender-based sexual harassment. Now, if we know that there is something strange going on, then we do something about it. We report it to the proper authorities, so investigation can happen before it gets to be what gets to grow, and then it is blown, it bursts, it explodes, and our whole school is going to be what is going to be answerable to a lot of damages that may happen. Okay, and then we get to pay because we did not do that which we should do prior to the violence erupting, or for the recurrence, or for the same acts to be done over and over. Now, the next one is once you caught or once a perpetrator, after investigation, always investigate because it is innate, even in our code, innate in all the laws and that had been enacted before this and even now and into tomorrow, that we get to respect due process, especially when we conduct our investigation. There's what you call procedural due process that is to be done when a school investigates a violation, whether it be a violation of your code of conduct in school or a violation of the laws of the land. There should be due process. And therefore, the perpetrator, the student, or the teacher, or the who else pa ba in our school, the janitor, our maintenance, our personnel, our non-teaching personnel, our administrators, whether central or specific, are found guilty, then the school may reserve the right to strip the diploma from the perpetrator or issue expulsion order. So this one is limited to students. Can our legal ground be the academic freedom? Well, actually, yes, that's also part of our legal basis, because part of that is the school may have a right to choose who among those who applied are given a slot in our universities or colleges. That's true. What we offer them and how they get to be formed, true. But there's also innate also, or that which is encoded in your student handbook. There's a stipulation there that says any violation of the laws of the land will also be subject to investigation. Or if found to be guilty, then it will be elevated to the regular courts. And therefore, we may withhold, okay? Or you can strip the diploma from the student who is graduating, or you can issue an expulsion order. You have to write CHED for that. For basic ed, we have to write DepEd for a petition for the expulsion order of the student for violation of this or that. Now, I'm going to give you a caveat here, because the law says this, then you immediately do it. No, it cannot be done. Aside from due process, aside from academic freedom, there is also notification. And due process means that the students must be notified. What does it mean? And where does notification comes? Does it come only once the action had been done, once the gender-based sexual harassment violation had been done, that you get to notify the student? The answer is no. You get to notify them even before. At the start of class, when you release the student manual or the student handbook, there is already a portion there in the student handbook that talks of this. Or there is also in your student handbook possible violations, that if they commit the violations, this will be their penalty. That is already published notification. Remember, when we release our student handbook, there is the class page there where the student and the parents get to sign that they agree that they be bound by this code of conduct, that they be bound by the stipulations or by the conditions of the student handbook, and that if found guilty, you can phrase it in your own way, and the student signs, ID number, and then in our case, we have the LRI number, because you only have the ID number, and then the parents' full name, and then the signature of the parent. So that, and then you tear it off and you turn it in to the Office of Student Affairs. So they have a compilation not only of the sample of the student's signature and their parent's signature, but also the agreement that binds the students and the parents to the school. And if it's found there, then this one will now come into action. You can strip the diploma. You can demand that a student is graduating cannot receive any honors or cannot even march, or you can write CHED for the expulsion order, or for basic ed, write DepEd for a petition to expel the students, and then you have there all the reasons for requesting for that expulsion. Because remember, it's only CHED or it is only DepEd who expels. It is not our school. Now, let's take a look at this one. I think this is more nearly almost, I'm almost done. Now, let's take a look at RA 7877, which was released in 1995. It was enforceable in 1995. And then RA 11313, released on 2019. And after publication of 15 days in the official gazette and newspapers of national circulation and also those of local circulation, now it becomes effective. Now, the main question that may come to mind is, we already have an RA 7877. Now there is another law, RA 11313. How are they going to be reconciled? Well, when you have two or more laws that talk or deal with the same purpose or same subject matter, then we call that in statutory construction pari materia, meaning of the same purpose or the same subject matter. And we have a lot of laws like that. Why did it happen? Because when RA 7877, this was what they believed to be the coverage. This is the scope of that law. At that time, there was no bastos-bastosan that happened. Actually, it already happened. But our 7877 made it very specific that this is going to happen on a physical space or online space involving in an educational environment, institution environment, training environment, or in a working place environment. That's all. That, within that given law, is the coverage, the scope of anti-sexual harassment, okay, against any person. Now, then what happened was, as the people evolved and as our community, our city, our nation evolved, there came into the existence now, actually existed before, but it came into our observation, begin to observe that 7877 does not answer certain actuations which are sexual in nature committed against male, female, or the gender-based, or those of different sexual orientation. And then if we only rely on one law, 7877, then that means to say, if an act had been committed, sexual in nature, but is not covered within the itemized or the details of 7877, then where will the complainant go? Well, you can go to the regular courts, but you cannot simply sexual harassment. What happens is you go into, it's very specific, very detailed with the perception of the harassment that happened to you. And therefore, it may fall under unjust vexation. Like if you were stalked. Stalking is not covered in 7877, even if it's done in the workplace. And so stalking is covered by an offense under the revised penal code, which is unjust vexation. You vexed me. You made me uncomfortable because wherever I go, you're there. Whatever I do, I find you there. In my online, you continue to harass me with invitations. Add me, even if I don't like. And then suddenly you go like, have my number because you got it from somebody, a friend or a friend or a friend. And then you started texting me. But that is not covered by 7877. So that would fall under unjust vexation. Or there could be certain acts that did not fall under 7877, where it could fall under acts of lasciviousness, and therefore it becomes an offense under the revised penal code. So then we have observed that there are certain crimes, certain offenses violative of the human person that we are, which are not covered under 7877. And so RA 11313 in April 2019 came out. Are they different? Later, we'll take a look at the difference, but let's take a look at the similarities because they deal with the same subject matter, they deal with the same purpose. So if that is the case, then RA 7877 and 113 must be consistent with itself. Can you file a case using only 7877? Yes. Can you file a case using 113? And the answer is yes. Can you file a case where it is answerable by both 7877 and 113? Yes, but that will be counted differently. So one count for 7877, another count for 113. Now, because it is in pari materia, then what happens is they must harmonize with the other. Why? To form a uniform system of jurisprudence, because the same subject matter. If you take a look at section 2 of both 7877 and 113, where it states the declaration of state policies, they are more nearly the same. But 1313 now has a very specific way of telling us what the reason, the motivation, the purpose of why this law was created, but did not in any way repeal the declaration given by 7877. If 7877 were considered to be repealed, then RA 11313 should have written it on the law that this is going to repeal the previous law. The fact that it did not, and therefore the both laws will have to be harmonized. So to form a uniform system of jurisprudence, okay? Another common point is that both 7877 and 113 has the demands from schools, demands from employers, the creation of a committee on decorum and investigation. And if you do not have that, then your school can be penalized, then the workplace can be penalized. Because as it is, there is also another doctrine that says exhaustion of administrative remedies, which means if this happened localized in our school or in a given workplace, you cannot simply elevate it to the court. You can if you wish, because there is no law that says you cannot. But in a school where we really have to take care of our reputation, because that is how we get students to enroll to us, then we control it, we manage it, not control. I think the term is we manage it within our area first. So we create the Committee on Decorum Investigation so that within the sphere of our school environment, we can investigate, we can come up with a resolution. Does it mean that while this is ongoing, the victim cannot file a case in our regular courts? He or she can file a case in a regular courts, but at least it will not be pointed out that our school did not do anything about it. Did it happen? Yes, so we were handling under CODI in the college this case when we were informed that the case has already been filed. The criminal case was filed before our local RTC. Did we stop the investigation? We did not. We continued until we came up with a resolution. And then when the student wanted also to get a copy of that, and we gave it to him, yeah, because it was the boy who was harassed. And then he also added that with evidence in court. Okay. Now, the third point that is common between the two laws is confidentiality. Remember, if you created a CODI, this Committee on Decorum and Investigation, during the investigation, in the listening of the narrative first, until the resolution, it has to be confidential. At no point in your listening to the narrative, until the end point, which is the handing out of the resolution, can there ever be a leak of what happened between this individual and this other individual to friends, to family members, to the public in general? None. Otherwise, your committee will be in hot waters because confidentiality is most important in the listening, from the listening to the giving of the resolution. Next, another common point is there should be, because it has to be, the CODI has to be created and had to function, then this must be published in the student manual or handbook and in the faculty manual. Question, Why the faculty manual? Remember, the faculty manual is the covenant that binds the faculty to the school. The student manual is the covenant that binds the student and their parents to the school. So both handbooks, because they're both covenants, must have this code, must have the procedure on how gender-based sexual harassment will be resolved or will be investigated. What is the process? What are the steps? And then eventually the resolution, where does it go? Okay, so all this, the process, the procedure, and how the we call that the implementing rules and regulation, will be particularly stated in the student manual and in the faculty manual. So everyone knows. Okay. The law even says it should be posted. RA 11313, just like 7877, shall be posted in conspicuous places. So that what did we do? We simply integrated into our student manual and faculty manual. All right. Now, this is not actually differentiation, but slightly certain things that you may see between the two laws. When we talk about the offender, I made a matrix on that one because a matrix makes things easier to understand. Okay. In the matrix, I pointed out, I saw 4 areas which could be common in their, well, both in their similarities and their dissimilarities. In RA 7877, the offender is a person in authority, person with influence, or person with moral ascendancy. Likewise, RA 7877, the offender can also be one who directly induces or choreographs, the inducer or the director, the choreographer of the whole harassment. So whether you be the principal by action, the principal by inducement, or principal by direct participation, okay, then you become part of what we call the offender. But I only cheered. In 7877, you are considered an offender by inducement. You induce the other to continue doing what he's doing because you cheered. Okay. Now, in RA 11313, the offender is anyone. You see, because there is no power play here, and therefore it's anyone. Be it a person who is at the bottom rank of the scale of hierarchy, or one who is on the topmost of the hierarchy. So as it is, anyone, whether it be in school or even outside. Outside, if it happens outside in a public space, physical public space, in a restaurant, in bars, or in groceries, in malls, in a marketplace, or even while waiting for a van to move you from one space to the next, or even in a private car that has turned grab, okay? The person there who committed this offense does not have any power on you, and therefore he belongs to the overall concept of anyone for violation of gender-based sexual harassment. Next, you have there, another one is reason, purpose, or motivation. For 7877, the reason, purpose, or motivation is power. I'm more powerful than you. Whereas, if you go for our 11313, there is no reason, no purpose, no motivation. You did it, one single act, series of acts. What is your reason? I don't know. What is your motivation? Why are you victimizing me? And the law says, I don't care. Because what is important is that you did it, and therefore you're going to be penalized because of that. Okay? So there is no joke time anymore that is sexual in orientation. No more. Because with RA 11313, anything, the concept of a green joke has been totally eliminated. Anything that is, in our language, bastos will have to be eliminated. And bastos, remember, could be racist, bastos could be regionality, bastos could be our ethnicity that we may consider as bastos. Bastos could be my orientation, sexual orientation. Bastos to me would be because of my being female. Bastos to me because I am male. In other words, at no instance are we going to crack jokes which would fall under bastos. But it's not bastos to me, said the offender. That is not a reason. To me, I perceived it as bastos. The focus now is on the victim. Power now is given to the victim. And so, no offender, whether I be in school, in the workplace, or outside, in the highway, walking, I should feel safe, that I will not be cut cold, that I will not be, what is this? Wolf whistled on. What? Woo! Why should you do that? I feel uncomfortable. So I'm going to file a case against you. Can that be done? Yes, because a perpetrator can be anyone. I don't even care what your motivation is. But miss, I really find you sexy. That in itself is a sexy statement. Additional count number 2. Okay, next. The focus when we go into the venue committed. Well, the commonality is it can be done in the physical venue, in the here and now, or it could be done in the online. Okay. How is it committed? We already said that. So it's both in the workplace and online for 7877. Here in the workplace, in the educational institution, and even online. Now, who can file the complaint? Okay, 7877. It is the victim itself, herself or himself could file the complaint. Whereas in 113, if the victim reneges or retracts, then it is the school that continues to file for the victim. I think that's about it. Okay, so then we go like, remember that our personal space is 2 to 4 feet. Very good, because now it's happening with social distancing. And to violate that space, if you go nearer me and I step back, that's a clue to you not to come any nearer still. Why? Because it is aggression. I will perceive it as physical aggression. Likewise, if you are to translate it to the online world, if you persistently stop me, or if you post on your wall something that is derogatory to me, that I perceived to be derogatory, or that I perceive to have sexual innuendos, then I would feel that my personal space has been violated, even if I know that there is actually no privacy in the online world. So that's about it. Have a nice day.
Thank you very much for sharing your expertise with us, Dr. Pilariza. Your presentation was very informative and indeed insightful, and I'm sure our viewers have learned a lot from you this afternoon.
Okay.
Let's now move forward to the second part of the program, which is the question and answer. For our live audiences, you may send your questions through the comment section below. For the meantime, attorney, I have one hypothetical question.
Yes,
For
wait, I'll just
example,
plug it in.
yeah, sure.
Yes, okay.
All right, all good.
What is your hypothetical question? Yes.
Yeah, for example, a faculty or anyone in the online classroom makes an unwanted, pervasive sexual remark, but does not but it's not directed to a certain person. Let's say just descriptive, but the descriptions would point out to one singular person. So how would that would RA 11313 apply, and how would you prove that?
All right, this is oral, verbal, in an online
Yes.
class. Okay. Your situation will dissect that. One is a comment sexual in nature was released. Okay. It was not directed to anyone because this anyone was not named. And that,
Yes.
on the second condition, even if not named, the class knows this one, the comment was actually pointing to this human person. Okay. Remember, even the naming of the victim does not have to be mentioned. If the others in the classroom believe that the statement released orally or verbally was directed towards her or him, okay, then it will come under RA 113 because the class perceived it to mean her or him. So if a statement like, say, in an online class, there was a break, or while the teacher was explaining, and suddenly one student raised a question and said, "Ay, sir, halimbawa, sir, and then the study even mentioned name. Ay, pwede ba, sir, yung kaklase ko, ewan ko ha, kung sino dito ha, wala naman talaga siyang skirt sa kanyang sinusuot sa bottom. Maganda nga sa taas, pero sa bottom hindi. Di ba, malabastos yun, sir?" Okay. You do not know who is being referred. However, the classmates are aware that there is one individual who does not wear anything at all, just only the bottoms and only, I don't know if he or she wears the panty or something, but they know that. And therefore, yes, they can pinpoint, you're referring to, that is, you know, in an online class, we must not forget that our decorum is similar to the decorum that we practice in a physical classroom. But this one is kind of upped. What do you mean by upped? Because we only see the upper portion, it is required from our students or from our teachers to be very careful when we talk about certain matters of this kind. In a physical classroom, no problem with our attire. But here, we don't talk about it. Yes. So
Thank you
therefore,
for
to
your answer.
yes.
Yeah, go ahead. Is there
You can
more?
still hear me, okay? My
Yes,
connection is
yes,
still
I can
okay?
hear you.
Okay.
Yes.
All right, yes. So because there is no innocent remark, there is also no bystander that will not get hit. The class knows every classmate in class. And to crack a joke like that, you're going to open yourself to a specific identifying of a person, even if not named, will be named eventually in that class. Okay.
Thank you, attorney.
Next.
You made mention earlier about the green joke or the joking culture that we have here in the Philippines. For example, the person who makes a sexual, unwanted, pervasive remark says, "Uy, joke lang ha," or atin-atin lang yun after committing or saying that remark. Does that absolve the person from RA 11313?
No, it does not. Because remember, there is no need for motivation, no need for reason or purpose. The act is committed, whether it be a physical act, verbal act, or online act, and that already exists, regardless of reason or purpose. So the excuse of, I joke, only joke, joke lang, joke, no longer exists. It can no longer be considered a defense. You uttered it, you wrote it, you grabbed it, you spread it, now you be responsible.
In layman's term, touch move.
Touch move, correct. So that when
Yeah.
our president uttered some before, now he does not do it anymore. We call them sexist jokes, and then we laugh,
Yeah.
but actually the women did not laugh because it's not funny. It's
Yeah.
not funny. And because it is not funny, we do not laugh. Rather, we don't get mad at him, of course, because we get to support him, whether you voted for him or not. But we, in a way, persuade him to remove that from his repertoire of jokes because it is no longer, and I love this term, no longer acceptable, no longer tolerable. And this one I love the most, no longer palatable. Hindi na siya delicious. You can't chew it and then digest it.
Yeah.
No more.
Yeah. Thank you for that, attorney. Let's now go to a question posted on Facebook by Maria Bruce. This is very an important topic nowadays because most of us doing online jobs and use online applications. How can we make sure that we are protected from these violations?
How can we make sure? Well, if
Yeah.
you read the law, there are certain authorities who get to handle this. For instance, you can have the police officer come in, you can have the LGU come in, you can have uh, any person who is a person of authority come in. Okay, how can we be protected? Hey, I once again go. I'm quite old, right? So, but I will try to be gentle. When is that? When can a safe word no mean anything or a value to another? When does it happen that when I say no, it gets to be valued by the other person? The answer to that is when I say it, when I believe it, when I act on it. So that the other person recognizes that I mean no, and that to me is a safe word and he respects it. So how do I get to be assured that I get respected? By making sure that I do not, number one, laugh at jokes that are sexist, jokes that belittle another of a different sexual orientation, jokes that I do not laugh because of the way this other person carries himself. When people see that I don't laugh, then they know that the safe word, no, it is not funny, is actionable on my part. And I honestly, I doubt if there is anything that they do when I am around that they will do this to make others feel belittled, to be harassed. So how do I know this? By, that's a very personal thing. But yes, you believe that you're safe and you act on that one. And then for the first time in the history of womankind, you do it. You feel safe. Now take note, because we think only the males are doing this. It's not. Even females can commit gender-based sexual harassment against the other person who's also a woman. Yes. And we think that it's okay. It's not. And therefore, if I don't do it, then you don't do it. If I don't do it, then you don't do it in my presence. So I will feel safe. Okay?
Thank you, Attorney. Um, just a follow-up question on that. Do you suggest that they have their phones handy so that whenever there's an abuse happening to them or done towards them, they can video record it or audio record it? Would that be advisable?
Yeah, but it's kind of funny. Why? While you're being harassed, you go like, say, wait, and then you have to like click your phone and I'll videotape it. But in the unfunny way, yes, I think it can be, because to have, remember, our phones already have the techno something, right? You can video, you can record anything. And the fact that you say, wait, I'm going to have this video recorded, or you take out your phone, that's already a threat on the other person, and they'll run away. So always make sure. Thank you, Jean. That's a wonderful suggestion. Very concrete. Yes, you can take out your phone and you make sure your phone can audio record and can video record. Okay, you can use that to threaten the other. But this one will be taken in, and I will give it to the proper authorities. Yes, but you also have to be very careful that when you do that, there is, no snatcher, no evil person behind you is going to snatch it away from you. But yes, a phone can be a good tool to use. Yes, and your strength of character. You must believe that you can say no.
And final follow-up question on that. Do you suggest also that the online classes be recorded as they happen?
The one who opened the online class has the power to record. If I'm the teacher and I opened it, correct? Whether it be Zoom or Google Meet or Moodle, because that's what we do with Ateneo, I have the power to record. But I always ask permission. The first day of classes that I had, one student recorded it. I don't know how he did it. He must be techno savvy than me. And then I said, wait. And he stopped and said, have you asked my permission? Have you asked the permission of your classmates whether they also want this class to be recorded? And he was a very nice gentleman, because he said, oh, I'm sorry, attorney, can I record it? Yes, but you have to remove the previous part where my permission was not granted. I said, okay. Then I said, class, is it okay with you to have him record our lesson? And they said, yes. They unmute themselves and go, yes. Okay. If you are to record anything, online class or online meeting or online chit chat with your friends, you must always ask permission. If that permission is not granted, then at no instance will you record, because whatever is recorded there will not be acceptable. It will be fruit of the poison tree. Why? Because you did not get the consent of those who are members of the group where the meeting or the class was on. Okay. Now, one moment. This goes also for the CODI. When you really have the CODI, and then you get to record your investigation, your meetings, the witnesses that came forward, even the narrative of the complainant and the narrative of the perpetrator, then what happens is you must request that the what is it, that the proceeding be recorded. If no permission was granted, then you cannot have the recording at all.
Yes, very much indeed. Consent is really an essential to recording anything. Yeah,
Yes,
thank you
even
for
in
that,
class.
attorney. Yeah,
Even in
yes,
class. Yes.
yes. We have a question here from Rosemary Amparo. What are the legal sanctions to schools who just sweep under the rug those sexual harassment complaints from students? Or are there any?
Yes. Is there? Yes, it is, I think, found on Section 21 of the law. Section 21, where there are our penalties, and what happens to a school who does not do anything about it, they will be civilly liable. Okay, this is Section 23 of RA 11313, entitled, the subheading is Liability of School Heads. So today, we cannot simply place them under the rug. We cannot. Everything is out in the open, and you have to respond. Okay, and there's a fine, 10,000, 5,000, 15,000. Okay, you go through this. Okay, penalty of the school for each case where you did not listen and you did not investigate.
Thank you, attorney. Next question is from Wenz Kagape. Will a non-publication of these in the student and faculty manual become a ground for liability of the school for this law?
Can I beg a question? It's actually called begging a question. Do you have a student handbook or manual that you release to the students after enrollment? This is accompanied by their IDs, by the uniforms that you sell, and by all others that you give to the students for a price. Do you have a student handbook? Because all schools, whether small or big, are required to have a student handbook that they release to the students. And therefore, let me answer your question. If we don't place it there, are we going to be liable? No. The handbook, as I've said, is a covenant between the student, their parents, and you, the school. It will regulate, govern their conduct, both academic and non-academic matters. If it happens that you did not place this RA 11313 there, and the procedure, what to follow when a complaint is presented to you, and what penalties, and all that stuff, then what happens is, if a violation is committed and that violation rests on RA 11313, there is no paper that you can present. So how then will you justify the penalty, like a suspension while the investigation is going on, or that you cannot march if it's a graduating student, or you cannot be given your honors because of this one, of your being decided by the committee that you have actually performed this? So what will be your basis? Will the school be liable? Liability would be if there is no following of the law. And if there is, and if that liability is going to fall there, then yes, the school will be fined. If the law says it must be published, it must be placed in conspicuous places, then you must follow. And one of the best conspicuous places for the publication of this law is via our student handbook and the faculty manual. So there.
Thank you, attorney. In the interest of time, we'll entertain one last question, and this is from Alexander Carrascal. Hypothetically, how about if someone is falsely accused of sexual harassment? What is his or her protection under the law?
Okay, remember that's what we call due process, okay? Therefore, the complainant will be called to give the narrative, and then her witnesses will also be called to give the narrative. The perpetrator, I will use the female version, will also give her narrative, and then her witnesses will also be called to give her narrative. And later on, you all submit your affidavits to buttress that which you have stated. Due process means both sides will be listened to. And then once everything is listened to and all the evidences are now gathered, then the committee will now base their decision from what had been gathered and the law. So What is the defense? That is now dependent on you. But take note, you must make sure that you have the witnesses, be very sure of what they're saying. So uh, because that will be your defense. If reasoning like it was only a joke, no longer a defense. So remove that from your list of defenses. I didn't mean it. Remove that also because you uttered it, you wrote it. Whether or not you meant it is beside the point. Again, that cannot be raised. So what else can you do? Can I have my mom and dad, just validate me as a good human person? They can validate that you're a good human person, that you're a good son, but it is non-essential to the violation that you have committed. So what is your defense? Your defense is, let's say, prior to. The defense happens before. That means to say, you be a good human person, you be respectful to everyone, no matter the sexual orientation, no matter whatever that human person is dressed or looks like or behaves. You be good and be respectful, you be truthful, and there is at no given instance in time that you get to have a complaint filed against you.
Thank you very much, Attorney Riza, for accepting our invitation and for being so game with our Q&A portion this afternoon. Do you have any parting words for our audience this afternoon?
Well, oh yes, my parting words. Oh, by the way, I would like to handshake all of you, but I cannot. The new handshake is this. Put it on your above, okay? Because there's a sexist joke on this, which I do not like and I do not laugh at all. Right here, and you bow. That means to say, I recognize you as a human person, and you also recognize me as a human person. My parting words is, as administrators, we always look out for our teachers and for our students. And as faculty, we look out for one another, for our colleagues, we look out for our administrators and our students. All of us make sure that our school remains a school where people get to trust and get to not sell, but send our students to us. We sell our schools via reputation. Our advertisements may not count a lot, but when one person, a graduate at your school, talks about your school this way, he sells the school and students come in. Actually, students do not care whether it's traditional teaching that we do or virtual learning. They're there because of the known reputation of your school. So keep it intact, keep it strong, because it is our school that we live and die for. Thank you.
On that note, that ends our webinar for this afternoon. Thank you once again, Attorney Riza, and we wish you the best of luck for all the endeavors that you will have for in the coming years. Thank you once again.
Okay. Thank you.
Okay, so that ends our webinar for this afternoon. For those who have pre-registered, you will be receiving the feedback form within an hour after this webinar, and you will only have until August 17 at 5 p.m. to complete the feedback form. The electronic copy of your e-certificates will be sent once after you have submitted your response. So on that note, have a great day, everyone, and thank you for watching. On behalf of Chairman Popoy De Vera of the Commission on Higher Education and the Director of the HECBOL Project, Director Nelly Alibin, we thank you for your support to HECBOL and our webinars. Have a great day.